All right, we are live. Hello, 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 hello. Good to see everyone today. Just gonna wait for the stream to catch up a little bit before we get going. Second. Just make sure everything's coming through. Coming through. Hmm. Uh, Double check. Oh, that's hilarious. It duplicated the. Okay, well, I gotta fix that. 1 second. All right. There. I just gotta mute this for a second, make sure the sound's coming in correctly. And that it is. All right. Apologies for that rough start. Well, you'd think I'd be used to doing this by now. You would be wrong. Anyways, welcome. Welcome to my video today on the art of catching liars. We're looking at techniques in cross examination. My name's Tim. You're watching Lost in Law. I will take you down a rabbit hole, get you lost in the legal world, and I'll do a little bit of an update on the Manitoba election today because I know that everyone is dying to see what's going to happen in Manitoba. I just know it. Got a feeling. Well, not much has changed. Not much at all. We're having a look at this. You'll recognize this from my last video. Um, this 338, again, an aggregator of polls that uh, span a lot of different publications and companies. And not much has changed. The last update was on September 16th. So even the media doesn't care about the Manitoba election. Hilarious. I made a couple of predictions last time, and I want to provide an update as to how those predictions are coming along. You'll notice that the parties haven't moved very much, but they have moved a little bit, and that little bit is significant because now they are favoring the New Democrat Party to win the election, and they're also favoring them to come up one seat short of a majority. They, of course, could form a coalition with the Liberals taking 2 seats here and get themselves that majority. These are 2 parties with very similar belief systems, and so they would get along just fine. The Democrats, the NDP party would be pretty equivalent to the Democrat Party, if you're familiar in the United States. And then, of course, the PC stands for Progressive Conservative. This little buffalo symbol, that's the Liberal Party. And then that green, whatever that is, I think it's a flower, stands for the Green Party, which you might be familiar with the Green Party in the U.S. Jill Stein, I think, is the leader of that party, or maybe someone else is, I don't know. But yeah, one of those kind of distant, I don't know. I don't even know how to describe these guys. They used to be a single issue party. Now they're they're a party to park the frustrated vote. Just like the Libertarian Party, which you'll notice does not register here in the top 4. But you'll see that some of the movement is trending upwards for both of these parties. Now, at the time, the Liberals were running at 11%. You'll notice that they've dropped down to 10%. I think the margin of error increased by 1. So they're still very unsure of where the Liberal Party is going to end up in this race. But I said that the path to victory for the Progressive Conservatives was through a strong Liberal Party finish. Well, that does not appear to be happening. Instead, you'll see the cratering of the support for the third parties here. Now, remember, I said that NDP voters and Liberal voters are quite similar to one another. And it's easy to imagine them changing between the two. And so what you're getting is the NDP is scaring all the Liberal voters by saying if you vote Liberal, you're going to let the PCs win the race. And it's starting to work. It's starting to consolidate voters in behind this one left of center party to oppose the right of center party. Although if you look at the promises that the Progressive Conservatives has made through the election campaign, I don't even know if I can characterize them as right of center anymore. I think they might just be center. Healthcare, especially in provincial politics, healthcare is always the top 1 or 2 issues through any election, at least any provincial election I've watched in recent memory. That was especially true in the Alberta election. We had a quick look at that last video. But healthcare in Canada, we have that universal healthcare system. Not free. Like, I know people like to call it free. It's not free healthcare. It just means that the person taking the money from me also has a gun to my head. I.e., they collect it through taxes. The difference, though, is that you can go into the hospital in the U.S., come out with a $200,000 bill, and you don't have to pay it all back right away. I don't get that option on my taxes. I have to pay them. When they're due, I have to pay them, or like our version of the IRS, the CRA, the Canada Revenue Agency, comes after you, and they'll just garnish your bank account. Because we have this cool thing called not caring about privacy, where the banks will just turn over all your records to the government if they're looking for your money. It's great. It's really fun. Yeah, I'm not sure what happened. That was a proposed law maybe 4 years ago, I want to say, in the Trudeau government. I don't know what came of that, but it's certainly been a poorly kept secret that if the government wants your money, they know where to go find it. We learned during the trucker convoy that under the Emergencies Act, they can also just freeze your bank account, make it so that your debit card doesn't work anywhere. I mean, I'm sure you all know what freezing a bank account means. I don't have to explain that, but um, yeah. I wish I had a decent update from the Tamaralets trial in Ottawa. There's not really, because there's no cameras allowed in Canadian courtrooms. There's not much to really go and illustrate, and I really don't want to rely on media reports because they will highlight things that they think is important, and I might disagree with what they think is important. So you might have to wait till the end of the trial. I can maybe order a transcript. Um, Very similar to the U.S., you can order court documents. I do believe I have to pay for them. Maybe now is a good time to show my website. Speaking of paying for things, but yeah, I'll do it at the end. But anyways, that's the trend in the Manitoba election. I won't take too long on this. Um, we have we have a debate coming up tomorrow, but it conflicts with something going on somewhere I have to be tomorrow. So maybe when I get back, I will turn the recording of the debate on, and we can watch it. And that way, I get the benefit of being able to pause and talk. Um, what I would do there is explain some of the techniques for presenting policy platforms and framing issues. Anyone who's got a background in communications will recognize a lot of those techniques, but um, looking at it from the mind of a data analyst would be, I don't know, maybe it'll be interesting. So watch for that tomorrow night. I don't know exactly what time. It depends on what time I get home from my other commitment, but I think inevitably I'll end up stepping all over Ricada as he's streaming, which is unfortunate. But I wouldn't feel offended if you guys decide to go watch his stream. You can always catch mine on replay. Political debates are interesting academic exercises, and it's today's video is all about the art of catching liars, and boy, are politicians liars. So I think that'll be a fun exercise tomorrow to just follow up this video. But the meat of the video, the real reason we're here today, I want to talk about cross examination. It's the art of catching people who lie on the stand. Now, I'm a big fan of House MD TV show that ran uh, years ago, ended now. I'm sure many of you are familiar with House, Doctor House. Uh, I've always subscribed to his cynical philosophy that he has in life, of the world and of people in general. It's sort of just as a commentary on the state of society today. Of course, you'll remember his philosophy talking about liars. Everybody lies, and it's true. I believe that. I believe everyone lies. I'm lying to you right now. I may have put makeup on. Makeup's a lie. It's an illusionary lie. No, I might have. I've got something that deals with the dark bags under my eyes. I don't think that's true makeup because it doesn't actually cover it. It just fades it a bit, but regardless. And it's not eyeliner or eyeshadow. You can look for yourself. Um, that would be funny if I just come onto a live stream wearing eyeliner. It'd get people talking. It would get people talking. I think people would enjoy it. So let's leave Manitoba and head on over a video I want to go through with everyone. You're going to recognize this. This was from the Amber Heard and Johnny Depp trial. And anyone who follows the other lawyers that I always shout out, and I have linked on my channel homepage, um, this has been covered to death. So I'm not going to offer much legal analysis here, but I certainly want to go through some of the techniques you use to cross-examine witnesses. The reason this works so well on expert witnesses, especially pompous expert witnesses, they believe they know better. They believe they're smarter than you. They get arrogant. They get complacent. And so as a lawyer, now in law school, no one will teach you how to bring the truth out of someone. That's just a natural instinct. Now, I'm not going to go too deep into the psychology of this, even though this is a psychiatrist on the stand. What I want to illustrate, what I want to highlight, is that anyone who understands the art and can perform the art can cross-examine a witness. You don't need to be a lawyer to be qualified. Now, of course, the only way you're allowed to speak in the courtroom is to be a lawyer. That's but that's regulatory. That has nothing to do with your ability, your qualification, and your capability of asking a witness questions and asking them good questions. Every question has a purpose. Always remember that as we start watching this video. Every question has a purpose. And when you're in cross-examination, and this is a, when you're in cross-examination, this is a witness who is friendly to the other team. So they did their examination, and they've had a chance to tell their story exactly curated as the way they want it to be. But when you curate a story, tend to exaggerate, fluff, or highlight things that is harmful to your own team. So the cross-examination is the chance to highlight things that are friendly to your own team, using their own words. It also is the opportunity to test their credibility as a witness. So keep in mind, I'll get this rolling in just a second here. The video is 26 minutes long. I think we can make it through the whole thing. I'll pause a couple of times and just talk about the formatting and the way that you answer questions. So some things I want you to keep in mind as this video rolls along. Number one, every question has a purpose. Number two, ask the question in a way that allows a witness to give you a yes or no answer or a one-word answer. What you don't want to do is have the witness give you an entire novel or an essay of an answer. A rule to keep in mind is that in cross-examination, unlike examination in chief, or first examination, you have the ability to ask leading questions. This witness is always presumed hostile under cross. So you want to tailor and narrow the question. You want to ask the question in such a way that lets them give you the best answer to your own case. You often operate from the benefit of knowing the answer to a question already, of evidence. You have you just listened to their first testimony. You have the benefit of knowing what the answer is. when you get the answer that's unexpected, have to be able to pivot and either go dive deeper into that question, challenge the answer you weren't expecting, and get them to catch themselves in a lie. Very few people will ever just directly lie to you and tell you something that is completely opposite of reality and not have any type of reaction or try to inject any type of any truth to it, or they will answer evasively. They won't answer the question at all. Well, you can't catch me in a lie if I didn't lie. That's the way that the brain kind of thinks. So it can be difficult for a lawyer to pin this person down into one position and say, this is your position, and I can refute that position with evidence that was introduced here, 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 and here. However, you're putting on a performance for the jury. So when the jury sees a witness get evasive, combative, and it goes both ways too. If the lawyer is overly combative with the witness, the jury will start giving that witness more credibility than perhaps they're entitled to. But when the witness snaps back at the lawyers, especially if it seems like the witness is doing so unnecessarily, their credibility with the jury starts to go down. And so you might not get the confession on the stand. In fact, you almost never get the confession on the stand. I certainly can't think of an example of one that's happened recently. Daryl Brooks notwithstanding. That's a whole other can of worms. Maybe we'll go into it someday. But yes, leading questions are an excellent way to frame the narrative exactly the way you want to be framed, and you force the witness to either agree or disagree with your framing. The art, now when I say the art of catching liars, it is an art form, not a science. The difference between science and art: science can be replicated. The same inputs should lead to the same outputs using the same process. Art is the opposite of that. It's variable. You don't always get the same result, even with the same process. That is what questioning witnesses is. It's not so much a science as it is an art form. Do everything correct and still come out with a bad result. That's why these techniques, they are not taught in law school. We don't have a course that's in law school entitled, here's how you examine witnesses. You will certainly be taught the legal, technical way to examine witnesses. The types of questions you're allowed to ask, types of questions you're not allowed to ask. In fact, lawyers ask witnesses questions they're not allowed to ask often. That's what an objection is. I object to that question for many, many reasons. There are many different reasons you can object to a question. You'll see some objections come up here. I'll try to catch them and explain them if I can. But one of the most, especially on cross, one of the most common. You can't object for a leading question. That's the one objection that's out on cross. But I think something that you'll see come up often is relevance. Objection, relevance. Again, you're trying to frame this narrative. Sometimes lawyers get focused on such a small detail that is so inconsequential to the rest of the case, to the questions of fact at hand, and they get lost. They go down a rabbit hole of pursuing this one little detail. And that's where you start asking questions that just aren't really relevant to the case. Sometimes you'll get the objection for badgering the witness. That's pretty rare. I think the courts give you quite a bit of leniency. And of course, those objections can be sustained or overruled. Sustained means don't answer the question, witness, and lawyer ask a different question. Overruled means witness, you can answer that last question. So let's have a quick look at this. Like I said, only 26 minutes. Bear with me for a bit. Oh, I should turn, let me turn capturing. That way you can follow along.
Dr. Spiegel, these opinions that you have offered here, do you hold them to within a reasonable degree of medical and psychiatric probability or certainty?
Absolutely.
Thank you.
All right, cross-examination. Thank you, Mr. Dennison.
So, of course, that what you just watched was the wrap-up of the examination of this witness. And so this was a witness friendly to Amber Heard. So her legal team brought the witness in, questioned him, and you just heard that wrap up. And you heard the judge announce that cross-examination may now begin. So now Johnny Depp's lawyers get the chance to come up to the stand and ask the witness questions. I want you to pay attention to the first couple of questions.
Sir, I'm Wayne Dennison. We haven't met. But let me ask you, let's start with what you finished with.
I'm sorry, one more time?
Let's start with what you finished with. You understand that the court was twice asked by Ms. Heard's counsel to order a medical exam of Mr. Depp, and those motions were denied.
Well, I think your team...
Okay, right off the bat, a question he already knows the answer to. He's just asking, did you hear this previous thing that happened? Right? Everyone in the room knows what the correct answer to that question is. And then you hear right away that the witness is not given. So it was a yes or no question, and the witness does not answer yes or no. And so the art, and a major portion of the art, is controlling the witness. Don't let the witness control you. And you're gonna see. Let's play, and we'll see here in a second. Hope you can hear that.
Told the court you didn't want to have them, and the court ruled on them, right? I don't think the court proactively did it. You kind of had a motion to them, right?
No.
Okay, so he mischaracterized what happened. Now, it's something important to remember. Lawyers cannot testify. So they have to ask questions. So you're going to hear the lawyer. It's almost like a weird game of Jeopardy. You're going to hear the lawyer state what happened, but in the form of a question. And you're going to hear this a lot in cross. Would you agree with, do you recall, right? Questions that allow the lawyer to state, this is what happened, and do you remember that's how it happened? The art form, obviously, again, if you're going to attack the credibility of a witness, you give them a softball question and make them disagree with you. Great, we're off to a great start. He's mischaracterizing what happened earlier in the trial. The lawyer's going to get a chance to correct him.
Ms. Heard's lawyers moved for them and asked for them and did not get them. Isn't that right, sir?
Isn't that right, sir? Right, he had to finish with a question. Lawyers can never make statements during the questioning of a witness. Everything has to be in the form of a question. Isn't that right, sir? It happened like this. Isn't that right, sir? Person A said this. Do you recall hearing that?
If you're saying that's what happened, my understanding of was that you all did not want him to undergo one. They petitioned for it. The court said no. Yes, that's what my understanding of it was.
The court said no to ordering Mr. Depp to do the medical exam.
Right, I said the court did not require it, right.
And there was one that was ordered, in fact, right?
There was...
All right.
Okay, so there was it sounds like there was an objection. They asked to approach the bench so that they could do the objection off of the microphone. Possibly they're getting into some privileged medical information, or they're getting into a hearing that wasn't done in front of the jury. They don't want the jury to hear what that Amber Heard's lawyer has to say. I'm not exactly sure what happened there, but we'll just move through this pause. I'm sorry for the buzz. That's from the recording in the courtroom. That's not my system doing that.
All right, so the last thing you talked about was the Goldwater rule.
Yes, sir.
Been around for almost 50 years, right?
Yeah, I'm 59. That sounds about right.
Yeah. And it's been around as a result of a presidential election that you referenced.
Yes.
They're talking about the Goldwater rule, which they're going to cover what that is in a bit, but you'll notice, again, he's setting something up. So he's asking questions that he already knows the answer to. He's making the witness agree with him. This technique goes, because very few people, if you just say, well, you lied about this, didn't you? They'll deny it. They'll say, no, I didn't lie. But if you start building that foundation, you lay one brick at a time. You agree with this premise. Okay, well, do you agree with this premise? Okay, do you agree with this premise? All right, do you agree with this conclusion? No. Oh, but you just told me you agreed with all of the premises, and now you're coming to a different conclusion. Right? That gets in front of the jury, and if the jury says, well, that premise, yeah, he agreed with that premise, agreed with that premise, agreed with that premise, I agree with the conclusion, but the witness does not, now the witness is seen as not being credible. You're going to see him build. And so, of course, you do so by asking questions that they're going to agree with.
And who has that rule? What organization maintains that rule?
The American Psychiatric Association.
An association you're a member of?
Association that I'm a member of, yes.
Yeah. Aren't you a fellow or something?
Yes, I am.
Okay.
Yeah, again, so a little evasive on that one, right? But then, of course, the follow-up is, so he didn't expect that question, but a sharp-thinking lawyer, he didn't expect that answer. But then a sharp-thinking lawyer says, okay, well, that wasn't the answer I was looking for, but I can get to there with this follow-up question. So you can see as he's moving along the line, he just loops back a little bit, gets the answer he was looking for, and continues on his line. On his paper, he has a list of these questions in a line, and he checks them off as he gets the answer he's looking for, because he's building that premise to the conclusion.
So, and this is an ethical rule, right?
It is an ethical rule. And yes, it's ethical. They say rules. It's an ethical guideline. Yes, they're guidelines.
Mm-hmm.
Again, he's just going to let him talk because none of that was harmful to the answer. The correct answer was yes. But of course, he spitballs a little bit, and that's fine. This is not something you would want to interrupt because he's not actually harming your question. In fact, he's strengthening the question by drawing more attention to it, by putting more detail into it. So you'll find that the lawyer is patient. When the lawyer interrupts the witness and says, just a yes or no answer, please, you can tell that he's starting to go off the rail onto something that the lawyer doesn't want him to talk about. And you'll find this a lot too. Witnesses, when they're like, "Oh shoot, I'm caught in this like lie, or caught in this thing that I don't like the way he characterized that, so I'm going to try and rehabilitate the answer on the stand. And so as a lawyer, you don't want that to happen. But, oh, what's up, Law Nerd Debbie? Thanks for hanging out. Of course, catch the replay anytime you want. I will, I'll have it. I'll leave it up on this channel and catch that later. And hope you join me tomorrow night too, as I go through Art of Debate. But anyways, back to the topic here. Thanks for hanging out. Of course, appreciate it. Back to the topic here. You're gonna find there are instances where the lawyer will interrupt the witness's answer. That is something that the other lawyer, the other legal team, can ask the judge to say, can you object? Can you let the witness answer the question? And so sometimes you'll see the judge intervene. So,
and you know that over time, the American Psychiatric Association has amended the rule, so it's not just about diagnoses, but it's also about professional opinions.
Could you be more specifically say about professional opinion in regard to what?
Well, let me...
Okay, evasive, right? So he was building up, talking about this Goldwater rule. He was building up to it, and now a little evasive. Because he knows he just stepped in it. He's off. What the lawyer is trying to show is that he offered a medical opinion that violates Goldwater rule. It's a medical opinion on someone he hasn't met. The Goldwater rule is you should not offer a diagnosis unless you have met with the patient. And that was, they made reference to a presidential election. I don't remember the history behind the Goldwater rule. I could look it up, but that's not important. What is important, though, is you can tell that he's like, oh, crap. I know where he's going with this, and now I'm going to start evading all of the direct answers. This looks so bad in front of the jury. Hey, I was agreeing with you here, and here, and here. I'm asking you another question that should have a yes answer. That's the way I asked it, on purpose. But you're not giving me yes. Why? And so, as he's thinking of what to say, a common tactic to stall will be, can you rephrase the question? Can you be more specific? Can you give me an example? Right? Things that you can use to delay. And so you're seeing, too, really, like, I don't dispute for a second that this is a smart man. The witness, Dr. Spiegel, is a smart man. The lawyer, Wayne, I forget his last, Vincent, whatever. I also believe he's a smart person. So you're seeing two fairly intelligent people who know what they're doing go against each other. It's a fun battle to watch. But remember, this is a cross-examination. You're in the lawyer's court. You're in the lawyer... well, I guess that's confusing. You're actually in the judge's court. But you're in the lawyer's wheelhouse. It's his expertise that's about to be displayed.
Let me read this and see if you're familiar with it. It is unethical for a psychiatrist to offer a professional opinion about an individual based on publicly available information without conducting an examination. That's the rule, right?
And an examination, of course, I guess in person is a little misleading. You could do it over Zoom, especially if you live in a remote rural area. But the spirit of the rule is that you cannot offer professional opinions about people that you haven't met and talked to. They also caveat that with publicly available information. If you're consulted, sometimes you can make that analysis if you're just given someone's file. But that's all highly privileged information, right? It's all under the Healthcare Information Protection Act. It's... So, of course, again, that's the case that he's trying to build. That's where he's getting to.
If you're reading it directly, I will believe you.
Okay.
Okay, why? Why answer it like that? If you're reading it, I will believe you. Why not just say yes? If you are an expert in this field, you should be familiar with the Goldwater rule. You should at least be familiar with the theory behind it, the spirit of the rule. So again, this looks bad in front of the jury, and we're just getting started. Only 3 minutes in, we're just getting started.
However, a diagnosis is not required for an opinion to be professional. So my question is, it's not just diagnosis that this Goldwater rule applies to, it's professional opinions.
So again, I'll reiterate that would come down to essentially nullifying witness testimony, expert witness testimony, without a direct evaluation. And as we know, it didn't happen. But regardless of that, the whole expert witness testimony thing would be basically rendered null and void.
The rule, in fact, contemplates that issue, doesn't it, sir?
Again, I'm just telling you the answer to the question. When you're reading me those statements, I'm telling you the response by the other side, who is publishes also, is that if that was the case, there could be no expert witness testimony in the courtroom.
Psychiatrists are ethically prohibited from evaluating individuals without permission or other authorization, such as a court order. That's the rule, right?
Again, if you're reading that, then I have to believe you're not misrepresenting it. And I would come back to, again, then this whole thing on expert, we might as well get rid of all the expert witnesses we've had throughout all of time for court proceedings. Because what you're saying is unless a court orders it, and that's what you just said, or the APA said, then therefore expert witnesses cannot do an evaluation based on an observation of the medical records. Insurance companies cannot do evaluations solely based on medical records with our doctors rendering professional opinions. So at the end of the day, you are essentially saying that unless someone has directly evaluated it, this whole medical system we have, this whole legal system we have, is null and void.
Okay, so he's not answering the question directly. And of course, now he's arguing with the lawyer. I love that there's some NHL scores scrolling at the bottom, too. Look at that. Calgary got defeated by Edmonton. Rangers, New York Rangers 3, Carolina 1. Awesome. Good job, Rangers. Carolina Hurricanes. Is there a hurricane? Oh, yeah, Hurricane Lee, I think. Canada. It's that season. But anyways, off track just a little bit. We're starting to see the witness try to take control of the narrative here. So at this point, I stopped it just before the lawyer asks his next question, because I want to predict what his next question is going to be. I haven't watched this video fully through. I did skip around a bit just to make sure that this was what I wanted to see. But I don't actually know what he's going to say next, and I sort of want to guess or predict. Now, it's either gonna be a quick kind of clarification question, but I also predict that he's gonna have a long lead up, because now the witness is starting to take control, and so in order for the lawyer to reestablish his control, he's gonna ask a question that has a pretty long sort of lead in, based on the premises that were covered previously, or the premises. Plural of premise. But that's my prediction anyways. Let's see. Or it could just be a very quick clarification question, and then he'll go into that long lead-in question. But let's see.
I'm not saying...
No, yes, you are, sir. No, you are.
Well, give me a second, and I'll give you more than a second. What I'm saying...
Okay, yeah. So there is a back and forth, which is never a good idea. You want to reestablish that control quickly when there's a back and forth between the witness and the lawyer. It's supposed to be a question, answer. It shouldn't be this debate going back and forth. So, again, reestablishing control of the witness.
And what I am reading to you is a rule by your organization that takes into account that there could be court orders that would permit the exact kind of evaluation that you say I'm eliminating.
And I think we're going in circles because I think I just said that means expert witness testimony would not be allowed, and the branch of forensic psychiatry would be especially hindered. And we know the branch of forensic psychiatry does not prohibit that. So I am a member of the APA. That doesn't necessarily mean every single thing they put in there, everybody has to uncategorically agree with, because clearly that's not the case.
Did you agree in your deposition that the professional opinions you rendered were inconsistent with the Goldwater rule?
Yeah, my first place, if we're saying that if the Goldwater rule says, and I very much said that during deposition, that the Goldwater rule was made for presidents and public figures such as that, but regardless of that, because that's what it was made for. It's not made for Hollywood, but I'll even take that Mr. Depp's a public figure. What I'm saying to you is that the Goldwater rule is saying we cannot do any expert witness testimony in our field. That is exactly what the Goldwater rule is saying based on exactly what you read. And I'm just telling you what you are saying that rule encompasses.
What I'm asking you, sir, is did you comply with the ethical requirements of the APA when rendering the professional opinions that you've rendered today?
It is a requirement of the APA. It is not the.
Okay. Again, make him lie to you, right? You're crafting this narrative, and honestly, this back and forth, this they're arguing semantics of semantic. They're arguing the semantics of the Goldwater rule and whether the APA guidelines are, these hard rules that you have to follow, or whether they're more of suggestions, things that, this is the way it should be, but we recognize that it's not always going to be that. So of course, you're going to start seeing the lawyer. This question again was tailored to yes or no, and he's not giving the yes or no. So the lawyer's going to bring this back and say, so is that a yes? Is that a no? What are you saying? Right? Clarify.
The requirement of the APA. Secondarily,
so the answer is no.
Secondarily,
there you go. Perfect, right? So the answer is no. Right? Again, take control of the witness. The witness is spitballing. The witness is saying things that are going way off the spirit of the question. So bring it back. So is that a no? Is that a yes? Again, it's a question. The witness has to answer. Unless there's an objection. You haven't heard any objections yet.
Secondarily, again, in order to not, we wasted our whole morning because there was an expert witness before me. There's an expert witness everyone brought in. So all I'm saying to you, that means the whole field of medical legal law is corrupt and unethical for engaging in an act that the APA clearly says we should not do. So if you're saying that, then the answer is yes, I'm agreeing with that statement.
You're agreeing that the APA would deem your testimony and your professional opinions rendered unethical.
I'm saying you are saying that I'm an expert witness. I'm saying as an
again, the clarifying question, right? This is a lot of fun. But again, what are you saying? Put it to the jury, right? This is all for the jury. Remember, this is not for us watching on the TV cameras, but it is for the jury.
Expert witness, and solely as an expert witness, that guideline is permitting that from occurring. I would say then that the whole field of expert witness testimony, again, would be disavowed by what you are quoting in the Goldwater rule. And we know that's not the case, because if it was, we would not be allowed to do it.
And you said the rule was for presidents, right? And
that was initially for
figures.
presidents, yes.
Well, and the name of the rule came from that. But the rule says it is unethical for a psychiatrist to offer a professional opinion about an individual. That's right, sir. It's not just presidents, it's not public figures, it's individuals.
Funny, it was named after the. According to your logic, if you don't put something in the title, it's not true. That's what you told me this morning, I believe, at my intimate partner violence. So, what I would say to you then, sir, is that if you say this about an individual, again, any court would have to render an expert witness testimony invalid. Any doctor that reviews charts would have to render it invalid. I can go on the list of docs that do not see or interview patients directly, and that's a violation. So basically, you are saying that unless you do a direct clinical evaluation, then all of the field of forensic psychiatry and all of managed care is doing an unethical violation because we are not seeing the presence. We deny patients medications all the time without seeing them. We deny patients treatments, unfortunately, without seeing them. And I'm on the receiving end of that. So the answer to your question, again, unless you were saying to me that all of this is unethical, which is what you are saying. This is how I'm interpreting what you are saying to me. That unless you do the evaluation directly yourself, therefore, it could not be considered ethical. And I'm telling you how that's applicable to not just expert law, but also managed care. It's applicable to multiple branches of medicine. Hospital duration of hospitalization stay, they get evaluated. So tell me where you want me to end this.
Well,
Sir.
why don't we?
Okay, so again, he's made a strong point, but I think he's missing the mark. It is a strong point though, and again, this is where you get two smart people arguing with each other. His point was valid, but I think it misses the mark, and so the lawyer just has to bring this back. And this is where you have to think on your feet, because there is no way he wrote down that this was the answer he was going to get to this question. So, the art of catching liars. This is the art that you're going to see with this next set of questions.
Why don't we talk about what you just testified to? Because I didn't ask you anything about that. I asked you whether, under this rubric, under this principle of medical ethics, have you acted unethically? Yes or no?
No. As an expert witness, I have not.
Okay, so again, lay the foundation, make them disagree with you. And again, the jury is going to look at this and say, well, some of the back and forth, they might tune out, or it might confuse them. But when it comes to simple yes or no answers, they're going to take note of that. Let's see how he rehabilitates the disagreement here.
Not acted unethically. And if you want the jury to believe that expert witnesses are unethical, then I guess that's for them to decide.
Yes or
that's
no,
for them
sir.
to
You
decide.
said no. Let's go to the next question.
Okay, take control of the witness, right? Spitballing again. Now he's talking. He's addressing the jury, talking to the jury. Just, it was a yes or no question, and we move on. And that, again, the art of lawyering right here. So you're seeing the lawyer try to rein the witness back in. It's a fun tug of war to watch.
Right? Psychiatric diagnosis occurs in the context of an evaluation based on thorough history-taking, examination, and where applicable, collated or collateral information. You'll agree with that?
I believe I said that earlier, yes.
Yeah. And it's a
Lay the foundation. Lay the premise.
departure from the methods of the profession to render an opinion without an examination and without conducting an evaluation in accordance with the standards of psychiatric practice. Correct?
Well, again, by the way, for the record, intimate partner violence is not a psychiatric diagnosis. I'll start with that. Substance usage by themselves is not a psychiatric diagnosis. If you want to cut to the chase, psychiatry is not a diagnosis of that. Narcissistic personality traits is not a diagnosis.
I think he's going to hang on to that last one there. Narcissistic personality traits is not a diagnosis. So, I mean, my legal training is, okay, so then what's the use? What's the use of testifying to traits? They're not a diagnosis.
Ergo, I am basically commenting on the things that were brought to me, which are not diagnosis. But an evaluation, if I was going to treat a patient or anyone here, those are the steps I would take.
We, I think, started with the notion that this rule applies broader than diagnoses. It applies to professional opinions.
I believe you just
rendered
quoted
professional opinions relative to narcissistic personality traits, haven't you, sir? Relative to Mr. Depp.
Again, I believe you just commented on what it takes to do in a psychiatric evaluation to establish a diagnosis. I'm almost certain that's what you said. And maybe I'm wrong. Maybe you didn't say that, but I'm sure you did. And therefore, what I'm saying is neither IPV nor substance usage, nor narcissistic personality traits a psychiatric diagnosis. And then under the rubric of expert witness testimony, you are saying I acted unethically under the rubric of expert witness testimony. So if you, sir, would like to proceed that expert witnesses are unethical, based on that, I am not going to sit here and disagree with you and waste everyone's time. I think it's fairly obvious. So thank you. Go ahead. These were your words. I'm just saying them back how they're interpreted.
Okay. Let's start with the easy question then. Maybe we can.
That was pretty easy. Go ahead.
All right, Doctor, you're going to have to just answer the questions.
Okay. Sorry about that.
Yeah, of course. Questions and answers. So you heard the judge intervene and just, the witnesses getting a little animated. So questions and answers is the way this is supposed to work.
You need to just answer the questions,
Okay.
Dr. Spiegel.
You are not rendering any diagnosis whatsoever of Mr. Depp today or ever.
Wow, okay. Tripped him up. So, of course, laid the premise, the foundation, right? All about this rendering a diagnosis. Okay, are you rendering a diagnosis? That should have been a pretty easy answer. Let's see.
No, I probably would say to you that certainly I would not say narcissistic personality, or I would say traits. Certainly, from what I have read, intimate partner violence is not a diagnosis. So the answer is no for that. Narcissistic personality traits is not a diagnosis. The answer is no. But if you want to tell me that substance use disorder is a psychiatric diagnosis, the answer is yes.
But that wasn't an issue, was it? Whether Mr. Depp used substances. I mean, you said you've gone through the record. That wasn't really an issue at this trial. He's said it from day one.
Oh, so you're saying he's already admitted to the diagnosis?
He's already admitted to the use of the substances.
Well, again, there's a difference between admitting to substance use and substance use disorder.
Let's go back to what you just said about narcissistic personality traits.
Yes.
Narcissistic personality disorder is a DSM-5 diagnosis, correct?
Correct.
Shout out to Ken Jennings, who might be in the chat today, but of course the DSM, the Diagnostic and Statistics Manual, I think is what it stands for. But yeah, it's like it's the medical textbook of the psychiatric field. It gives you all of the criteria in order to render, when you do clinical evaluations, it gives you all of the diagnostic criteria before you can say that someone has a certain disorder. So that, of course, would be the reference book that this expert witness consults when rendering medical diagnoses.
Diagnostic personality, and you haven't testified that Mr. Depp has narcissistic personality disorder, have you?
I would certainly, if I didn't, I'm certainly thinking that, but at least I'm going to say he has traits which are characteristics of
Okay, again, yes or no question, and you didn't get a yes or no response.
provisional diagnosis of, it's a provisional diagnosis of probably narcissistic personality disorder. But yeah, I mean, I do believe that.
Well, but when you say provisional diagnosis, you know the DSM-5 requires, in order to find that diagnosis, 5 of the 9 factors.
Mm-hmm.
And you haven't done that analysis. You've never made that diagnosis. You've just identified certain factors.
That are criteria for the diagnosis.
Right. But you need 5 of 9 to get to the diagnosis. You've already told us that you didn't make a diagnosis. You're just identifying traits, correct?
I'm identifying traits that are consistent with the diagnosis, yes.
No, that's a artifact from the video that must have been a glitch in the internet feed. I guess this is a TV truck, so satellite.
That there is no literature at which you are currently aware that the mere presence of narcissistic traits is a risk factor for IPV.
Am I answering the question?
Yes.
That's incorrect.
You didn't testify that.
A cluster B traits, which narcissistic personality disorder is part of, is a huge risk factor for intimate partner violence, which include, cluster B traits include narcissistic personality disorder, antisocial personality disorder, amongst others. So the answer to the question is every resource on intimate partner violence will support that cluster B traits, where narcissistic personality falls under, is a risk factor for intimate partner violence.
Any single trait is a risk factor for IPV.
Again, I will repeat, cluster B traits. I didn't say any trait. I said cluster. No,
let me be more precise then.
Okay.
Any narcissistic trait in and of itself is a risk factor for IPV.
But you are mischaracterizing what I said. What I said, I'm pretty sure.
Oh boy, you know that so the lawyer is trying to pin him down on something, right? Because if you can pin a witness on a statement and then introduce evidence that refutes that statement, you have done a massive attack to their credibility. And so the lawyer gets frustrated here because he's like, just say yes or no. For crying out loud, why? I mean, and to the witness's credit, he's not letting himself get bullied in this case. So Dr. Spiegel is not allowing the lawyer to lay down his narrative unchallenged.
I said cluster. If you look at all the intimate partner violence literature, and I would behoove you to do so, you will see that cluster B traits. I didn't say narcissistic per se. Cluster B traits, where narcissistic personality disorder is part of, are risk factors for intimate partner violence. Part and parcel, uniformly true.
So that means, so he's taking it from the other way, right? He takes it from the IPV direction and drills down to one of these traits as part of this. What the lawyer's trying to ask is, so you're saying that those traits, any single one of those traits, leads back. So he's just trying to reverse the chain. And Dr. Spiegel is being evasive when he answers that. Because what the lawyer's trying to establish is that there is one of those 9 risk factors that doesn't lead to intimate partner violence. There is not a huge risk factor of intimate partner violence. That's the foundation he's going to try and lay. And Dr. Spiegel is not agreeing with him.
And I'm not sure, the thing I don't understand is I'm not sure why we're arguing psychiatry, because I'm telling you what it is.
Dr. Siegel, you just need to answer the questions.
Okay.
Again, judge checking the witness.
So you want to talk about cluster B, so let's do that for a minute. Borderline personality disorder is a risk factor for IPV.
As part of cluster B traits, yes.
Histrionic personality disorder is a risk factor for IPV.
Less so.
But
less so.
It's good.
Less so. I mean, it's a risk factor, but less so, yes.
Yeah.
Less so. Significantly less so.
All right. So which traits under narcissistic, before I move on there, there's only been one diagnosis in court of personality disorders, correct?
I'm not sure who you're referring to. Are you referring to Mr. Depp, Ms. Hurt? I'm not sure what you were talking about.
Do you understand that there was a medical examination done of Ms. Hurt?
Yes, I did.
Do you understand that the testimony was ultimately that Ms. Hurd suffers from 2 personality disorders?
Okay, so I'm just being specific. I just wanted to know if you're talking about Ms. Hurd or Mr. Depp. So that's all I was asking you.
Yes or no to my question?
Which was there's only one diagnosis of Ms. Hurd was diagnosed with that.
Yeah, and both of the diagnoses are in cluster B, and both of them are risk factors for IP.
Oh, right. This, he was trying to get to this earlier, and Dr. Spiegel was being evasive, but this is where you're starting to see, use his own words against him. Because he just spent almost, 7 minutes making very clear that those diagnoses are risk factors for intimate partner violence. Oh, wait, someone was diagnosed with that, but it wasn't Mr. Depp, it was Ms. Hurd. Oh, crap. Now I have to... And you can see where he's going with this, right? It was all set up with the arguments made 7 minutes ago. And now the lawyer is able to execute his final maneuver because he got the premises in place.
EV.
But both those cluster B things are. I'm not allowed to comment on the testing, so therefore, all I could say is that cluster B traits, and I'll tell you what they are. And by the way, I testified this before, which was that 1, I don't expect perfection from my victims. 2, absolutely there were cluster B traits Ms. Hurd had. Absolutely, Ms. Hurd had.
Given that you've testified to it before, let's move on to a new question.
Okay.
All right. You indicated, in your opinion today, that you thought, well, why don't we move a little different? Are you a member of the American Medical Association?
No.
Okay, so you don't know what the ethical rule of the American Medical Association is relative to doing clinical diagnoses about individuals you've never talked to.
So you're saying in terms of doing expert witness evaluations under that rubric, right?
I'm just asking you, do you know the AMA's rule?
You're saying the AMA's ruling under the rubric of not doing evaluation, some of you did not see, and I'm questioning, I'm asking, so you are talking about expert witness testimony?
No, I'm talking about, do you know the rule?
I'm not a member of the AMA, so I don't read the rubric.
Okay, move on. You don't know the rule.
Again, sometimes the frustration with expert witnesses, especially when they think they know better, right? It was a very simple question. He made that much more complex than it should have been. And that's why you're starting to get a chuckle out of the gallery. The people you see seated back there are just members of the public watching the proceedings. That's not the jury. You're not allowed to show the faces of the jury on camera. So you're just hearing a little bit of chuckling out of the back benches there because, again, the lawyer wins that exchange because it's like, I asked you a very simple question and you made it way more complicated than it should have been.
All right. You rendered an opinion about Mr. Depp's purported cognitive impairment.
Yes.
Yeah.
Premise.
What do you use as a baseline?
A baseline for processing speed?
Yeah, for analyzing Mr. Depp before you watched his deposition.
What do I use a baseline for that?
Yeah.
I mean, I guess my baseline would probably be how I've seen him interact in public. How I've seen him interact with others. I've seen him interact in media. I've seen him interact and his process speed is certainly not slow. I've seen him do commercials. His process speed was not slow.
At deposition, didn't you say that what you did was compare Mr. Depp's performance in lots of pirate movies?
Deposition, by the way, is it's a pretrial evidence gathering exercise. It's where it's in the process of discovery where lawyers can call potential witnesses in a trial to um, give them to answer questions they would have as part of their uh, fact finding and evidence gathering exercises. And so, um, discovery goes hand in hand with depositions. It's a chance for the other team's lawyer to say, you know, you're going to be a major witness in this trial. I have some questions to ask, right? And that's how. So when they refer to the deposition, that's what this is. This is the pre-trial interviews of witnesses. I'm not going to go into the deposition process. I haven't. There's this would not be the video to show. And getting your hands on deposition videos is really, really difficult because they tend to be quite privileged between attorney and client. So, again, very difficult to get your hands on a deposition video. But yeah, when they're referring to deposition, that's what they're referring to. So these lawyers have had, Johnny Depp's legal teams had a chance to sit down with Dr. Spiegel pre-trial and ask him questions.
Against his deposition testimony
What
here?
what I said was I've seen Mr. Depp do apology ads. I remember he did an apology ad with Bad Dog with no delay in process speed. I've seen him interact with the media regarding to that. I saw no delay in processing speed. All I'm saying.
Let me ask you about Pirates, though. You compared Pirates to the to the depositions given in this case.
Then I apologize for what I said. Then I misspoke.
You misspoke? You didn't make the comparison?
Right now, just a second ago? Just a second ago, I may have said that I misspoke. I apologize, I misspoke.
Okay. Because you know you can't compare Pirates to sworn testimony, right?
Yes.
Okay.
But you can, but as an aside, you can judge someone's processing speed at any time. Like I'm judging yours right now, you're judging mine. We all judge processing speed as a baseline because of what we know about each other. I would say your processing speed right now is not slow. So, we're judging processing speed. I'm just saying to you.
Trying to butter up the lawyer.
Yeah. But no, any of Mr. Depp's other portrayals in movies, did that affect your analysis of processing speed?
Only I've seen him interact on interviews, and that was it.
Right.
When he wasn't in movies.
Right. But Willy Wonka doesn't matter to you? You see him in that movie, Charlie and Chocolate Factory? Did you look at that one when you were comparing his processing speed?
Do I have to answer that question, Your Honor?
You have to answer questions. Yes, sir.
No, you'll be happy to know I didn't see Willy Wonka I didn't see 21 Jump Street when it happened, or whatever it was about. No, I did not.
All right. You made a very kind admission, I think, early on in your deposition, that you're not claiming to be a better actor than Mr. Depp. That's correct, isn't it?
100%.
All right. But with respect to acting, you know that actors actually rehearse for their parts and work on the language, diction, timing of their dialogue as part of that rehearsal?
If you say that, I'm not an actor, so I don't know what goes on. I can't tell you. I have no idea what goes on in acting.
Okay, but you don't know enough about acting to know whether actors rehearse?
Sir, I am not an expert in acting. I have no idea what an actor does.
Okay.
Yeah, it looks like there's going to be a...
Sir, I'm Wayne Dennison. We haven't met.
What I think I said was that if you're going to do a major thing to a trial that you're involved with, I think you'd be an idiot to come in the... Okay. So I think it was in the context. Probably should read the context of it, because I'm not an expert in acting. I have no idea what an actor does.
Okay. Yeah, okay, so I didn't realize that video cut off early. There is more testimony than what that video had. So we're just going to continue along with this really quick. Stupid Fox News.
During your deposition, what were the circumstances under which you decided to call Mr. Depp an idiot?
Under somebody call Mr. Depp an idiot?
Yeah, you called Mr. Depp an idiot in your deposition. Why
I
did
think.
you?
Okay. So I think it was in the context. I think it was in the. Probably should read the context of it, because I think the context was, and I'm trying to think back. Okay. And what I thought it was related to was if you're coming to some deposition, okay. And again, I'm thinking back. So you have it in front of you. I don't. So I'm thinking back where he's coming in from Europe for a deposition, video deposition that he gave, and he took an overnight the night before. And what I think I said was that if you're going to do a major thing to a trial that you're involved with, I think you'd be an idiot to come in the night before.
All right.
So I didn't call Mr. Depp an idiot. I certainly called that planning an idiot. I didn't call him an idiot.
So the words "so I mean he's an idiot" are mistranscribed?
No, I'm sure. Again, if I said it in that, if you're just reading one line, one snippet, I'm sure it was in the context I just said. But again, you have it in front of you. I don't.
Yeah. Is idiot a professional opinion?
I wasn't rendering professional opinion. No.
Is it a psychiatric opinion?
And that follows the Goldwater rule.
How does it follow the?
Oh, you just said that I'm not rendering a professional opinion. I just said idiot. That's not a.
Right, so idiot is not a professional opinion. Mm-hmm. Is it your practice to describe people as idiots?
In my practice, in my practice? No, I don't describe my clinical cases as idiots, or patients as idiots, or victims as idiots. No, sir.
But you sat for a deposition in this case and described the plaintiff as an idiot, correct?
You gave me 9 hours of deposition, and if I said the word idiot, it was an idiot in planning. It wasn't making him an idiot. I don't know Mr. Depp's IQ. I don't know his overall functioning. So therefore, if I said it, it was an idiot in planning, which is what I meant to come across as.
All right. So you did say you don't know his overall functioning, but you made some testimony today as to some evaluations you made relative to his functioning. You would agree with me that it's...
Again, attack him with his own words. It's not enough for the lawyer to go up and say, you're being evasive, you're lying about this, you're not being forthcoming with this. The best way to deconstruct expert witness testimony is to use their own words against them. And you're seeing that a lot. You're seeing him quote Dr. Spiegel in order to attack the credibility of Dr. Spiegel. And this is where the art form comes in, because you never know how this is all going to, how all of this will run. And so when you do get the answers, and you can see him flipping back and forth between pages there. And again, those are the questions, those are the points of evidence he's looking to bring out through the questioning. When he gets what he wants, you'll see him then follow up with another question that perhaps gets much more accusatory.
Probably a good idea to think about the questions that are asked you in a court proceeding before answering them.
Am I allowed to answer that question?
Yes.
Okay. So what I said by function, I believe that his agent reported how late he was showing up to every movie while the cast is waiting for him. I believe that would be an impairment. If I showed up late for that, I would not be here right now, would not have a job. Okay? I believe the thing was in terms of balking out of treatment for substance rehab that his doctor is prescribing for him. So if you're asking me if that's an impairment of functioning, I would say I'm very much substantiated in that.
I'm trying to understand how you got to this notion of cognitive decline. And I thought it was based, at least in part, on the manner in which he testified.
I'm sorry, what?
On the manner in which he testified.
On the manner, I'm sorry, I'm not being difficult. I can't hear. I'm sorry. On what?
I was asking you about the cognitive decline testimony that you made.
Yes.
And it was my understanding that at least a portion of that testimony that you rendered was that you derived some evidence of cognitive decline from the way Mr. Depp testified.
Yes.
Okay.
And that's what I said, yes.
Right. And so all I'm asking you is, don't you think it's a good idea when you're in the middle of a court proceeding to answer questions carefully?
Again, professionally, we diagnose patients with a neurocognitive disorder by gross evaluation all the time with cognitive. On the thought that, again, age normal controls, I'm just saying, age normative controls does not put a 58-year-old gentleman at that processing. That's all I'm saying. That's all I said.
And you derived this without ever once talking to the man.
Me directly talking to him. Because we know how I derived it. So you're talking about me directly talking to him?
Yeah, you never talked.
No, I've never talked to him.
Right. And this exam you gave, well, you did talk about Dr. Blaustein, right?
Yes, sir.
And you understand that the entirety of Dr. Blaustein's medical records are 12 pages of handwritten notes.
The important part was what I said. For me, as an example of cognition, which I'm trying to prove, which is what you asked me, the important part was what I said. And that was irrefutable.
The important part is that he gave the mini mental status exam?
Yes, sir.
All right.
That's
Let's talk about the mini mental status exam. Scored on a 30-point scale, right?
Yes.
All right. And it's an exam that basically is most often used for what, Alzheimer's, dementia, those kind of testing?
It's an exam that tests cognition in all psychiatric illnesses, not just Alzheimer's. It was made for dementia for Alzheimer's, but is the standard, has been the standard for testing cognition in all psychiatric illness, substance use disorders included.
Okay. Now, there is an element of that exam that requires drawing, correct?
Yes.
So you don't know what drawing Mr. Depp did or whether the drawing should have been fully scored.
I wasn't questioning his visual spatial perceptual skills, which is what that does.
Right. And you don't know what score Mr. Depp received on the exam.
I was very specific. I know 3 words, not remembering at 5 minutes. That's all I said.
3 words, not remembering 5 minutes, and he remembered one of them, right?
From what I understand, he didn't remember any of them.
All right. Memory on the exam. Out of the 30 points, what's it worth? 3. 3, right? Memory is 3 out of the 30.
Yeah, memory's 3.
Okay.
But again, the memory section in and of itself tests memory. That's the only question that tests memory. Only section that actually tests memory.
So the memory section tests memory. It's the only section you testified about. And for all you know, that with respect to the exam that you're relying on, Mr. Depp scored 27 out of 30.
And that would be telling, though, cognitively, if you score 27 out of 30 and you miss 3 points on memory. That would be very telling.
You don't know if Mr. Depp had been up all night the night before.
Again, you wouldn't expect to not recall any words at 3 minutes unless there's a cognitive issue.
You don't know if Mr. Depp was high.
And again, now that's, again, now that could affect memory, but I'm not refuting that. I'm not refuting that at all. He could have been high, he could have been drunk, he could have been using cocaine, and that would absolutely affect his memory, which is what I said. Yes, you're right.
So ultimately, you have no idea what state Mr. Depp was in at the time he took the exam that you're relying on.
So you saw that setup, right? You saw the setup. The premise, and now you've got, okay, I can nail you on this because you just agreed to all of the previous facts. The facts lead to this conclusion. And then you see Dr. Spiegel, okay, now it was his evasive again.
Short of what you just said about drugs and alcohol, okay, there shouldn't be a reason why a 58-year-old also with strokes and other neurocognitive conditions, but short of that, there shouldn't be a really good reason why someone at that age shouldn't come up with at least one. But an answer,
But wait a minute, you started that question with short of drugs and alcohol and spent 35 minutes talking about his use of drugs and alcohol. Isn't that right?
oh, I'm agreeing. I thought I agreed with you. I think I agreed. I said that drugs and alcohol can absolutely affect cognition. I'm not sure. Yeah, I agree, but I'm not sure if that's a problem. I agree with you on that.
All right. So you don't know, one way or the other, how he scored on the exam. You don't know whether he was at the time on drugs and alcohol, but you're going to rely on it in your testimony to say that he's cognitively impaired.
Which is what we do in clinical medicine, sir.
Okay. You rely on tests that you don't know when it was administered, you don't know the score of the test, and you don't know the state of the person being tested, but you're going to rely on it anyway.
Again, if we had to know every test, when people get the mini-mental state exam, we have no idea clinically if they are high, wasted, stoned, stroke. We have no idea. So if you're going to say that, that means everybody needs a drug test before they do a mini-mental study, and that's not the standard of care. And I think you know that. So
let's talk a little bit about this word you kept using, correlation. You know the word, right?
yes,
Correlation and causation aren't the same thing, are they, sir?
no, they're not the same thing.
No. How are they different?
Correlation is consistent with causation, is direct link.
Can you say that again? You were so fast I didn't hear it.
I'm sorry about that. Correlation is a risk for something happening. Causation is a direct link.
Right. So just because something's correlated doesn't mean it's going to happen.
100%.
Right.
100%.
But lung cancer, for instance. Smoking is very highly correlated with lung cancer, right?
Yeah, and there's certainly a link
Right.
to lung cancer and smoking.
Right. But not all smokers get lung cancer.
Not all smokers do. No one, like I said, no one fits the curve perfectly.
Right. And you've made repeated testimony to all of us. All of us do this. All of us do that. Mm-hmm. Your suggestion about all of us is you're just looking at the world as a sample and not at any particular individual, correct?
What I'm looking at is that I'm not talking about an individual, how they can or cannot be resistant. What I'm saying is invariably, when you use substances, this is going to happen. Now, is there a 0.05% chance that someone who does? Absolutely there is. But is that medical degree of certainty? Absolutely not.
A 0.05% chance of what, sir?
Of eventually developing symptoms. If you're using excessively, eventually you're going to develop symptoms.
All right. But risk factors tell us nothing about any one particular individual, do they, sir?
No. Again, risk factors tell us nothing except that if they have it, they're at a higher likelihood of developing it. That's
Right.
what it tells us.
But you did a whole litany of risk factors relative to IPV.
Yes.
Right. And none of those risk factors tell us anything specifically about an individual.
Other than they're at higher.
So you recognize this as a callback to that previous testimony about the narcissistic personality traits being risk factors for intimate partner violence. Starting to see him bring this back around full circle.
Right. So someone could have every single risk factor for IPV and never commit IPV, right?
It would be, again, if you're going to say a medical degree of probability, the answer is they will. But if you're saying uniformly, the answer is no.
Right. IPV can occur without substance abuse.
Oh, sure.
Someone can abuse substances without ever perpetrating IPV.
Again, absolutely. But, again, you are saying different than what I said. I did not say abusing substance. I said substance use disorder. Those are two different things, because there are surely people who use substances that do not engage in any violence, do not become psychotic, nothing at all. So
And that's
absolutely.
equally true of people who have substance abuse disorder. There are certainly people who have substance abuse disorder who don't commit IPV, correct?
They are saying people who have substance use disorders, the majority of them, over 50% do. So over 50% do. So that's medical.
The answer is yes.
As you said, not everyone who smokes gets lung cancer.
So there are significant numbers of people. You said it was over 50, so you'd say 40% of the people who have substance abuse disorder don't commit IPV?
And those are the ones that do not have IPV risk factors, right? So we're talking about people
Wait a
who
minute.
don't.
Isn't substance abuse disorder an IPV risk factor?
Oh, yeah. These are other people that don't have other risk factors, right?
But again, we're talking about people in general. You don't know anything about any particular individual as to whether anybody's going to commit IPV.
If statistics follow through, all we can say is more than 50%, 70% will. If you combine more risk factors you have, the more likely you're going to develop the illness. If you smoke cigarettes once, that might not correlate to lung cancer. If you smoke it chronically, that might. So
Right,
that's
but
all I'm
we're
saying.
talking about individuals here. You either have lung cancer or you don't, right?
If you're smoking.
Right.
Right.
You either commit IPV or you didn't.
Oh, I mean, yeah, you either did or you didn't, yes.
Right. So you took some issue with me because I was asking about substance abuse generally, and you wanted me to talk about the disorder. I asked you earlier about narcissistic personality disorder, and you haven't made that diagnosis. You've just talked about the traits, right?
Yes.
And somebody can have these narcissistic personality traits and substance abuse disorder and never commit IPV, right?
So, along that line,
Right.
about 80 to 90% of people who commit IPV have a personality disorder. So the answer is less than about 10% obviously do not.
Right. There are more close links with IPV for borderline personality disorder than narcissistic personality disorder. Correct, sir?
I'm not going to agree with that.
No?
I'm not saying there are more links. I would say to you, there are absolute. If you're asking me if there are links, the answer is absolutely. If you're saying to me more, I can show studies, say yes, show studies say that has not been absolutely definitively correlated. No.
No.
Absolutely not.
All right, so this back and forth. I mean, I think we can see what conclusion we're trying to get to. I love that the other lawyer is like
MDMA.
lining up candies.
What is it?
Maybe they're pills.
Ecstasy.
Yeah. And what's the normal dosage of ecstasy for people who use ecstasy?
Again, I couldn't tell you the quote-unquote normal dose because, honestly speaking, no one knows what they're getting when they're using it, right? It's not regulated, so.
But the effects of ecstasy enhance sense of well-being?
At low doses, the answer is yes. I'm going to gather when you're using it at higher doses and develop tolerance, you develop the sympathomimetic effects, which are not so enhanced well-being.
Increased extroversion, that's a symptom?
Again, at lower doses, you are 100% right. At low amounts, you are 100% right. It is an entactogen. We feel closer to people. That's what people who use it say. They feel close to people, warmth to people, 100%. But with continual use and higher doses, it could be fatal.
Right.
So that's not well-being. I don't know if I call that well-being.
So continued use at higher doses, MDMA can be fatal, correct?
Correct.
if you took 8 to 10 tablets of MDMA?
What if you took again, you don't know what it's very hard to say that. You don't know what it's, what's the word I'm looking for? Contaminated with, okay? You can't just say, hey, let me just take 8 to 10 pure ecstasy and see what happens. Yeah. That's not gonna happen. So what I would say to you, again, because substance abuse are unpredictable, they are not regulated, no one knows what they're going to. No one absolutely has any idea whether it's going to cause this empathic and tactogen effect at very low doses, or is it going to cause the increase, it's like a stimulant, like cocaine and stuff we talk about like that. No one knows what's going to happen. It's not regulated. And no one knows if you're using with other substances either, like other stimulants.
Or if you mix it with alcohol.
Or if you mix it with alcohol. No one knows if it's going to be potentially worse.
Right. But this is a potentially lethal combination. 8 to 10 MDMA tablets and alcohol.
This is a potentially toxic combination.
Right.
Can it kill you? Yeah, I mean, it is a potentially toxic combination. That's true.
Ever heard of someone cutting off their own finger on MDMA?
Have I ever heard of it?
Yeah.
No, I can only give you one example.
Hadn't seen that one before. Okay. So, Seroquel. That one puts you to sleep.
So I think the finger was a reference to that the allegation was that Amber Heard had chopped off like one of the tips of Johnny Depp's fingers. That's what that was a reference to. And we're getting into some meaty and nitty gritty stuff right now, so there's not a whole lot of commentary I can offer on this because there's not really any line at this part. But
right.
If you want to phrase a barbiturate putting you to sleep, then the answer is yes.
Yeah, you heard Mr. Depp talking about sometimes being on the nod, right?
And again, I think I explained Seroquel very well this morning.
Good. I'm going to ask him a few more questions.
Oh, okay. Okay.
All right.
That was an evasive answer.
You're making references to street value. Why were you doing that?
Because that's why people with substance use disorder use quetiapine and Seroquel.
Say it again, I'm sorry.
That's why people who use quetiapine or Seroquel it sells on the street because it's so barbiturate-like in effect.
Right, but you said that Mr. Depp had a prescription.
There are many substance use disorder patients who have prescriptions for Adderall and quetiapine from their doctor, and that doesn't mean they're not getting high out of it. That doesn't take much. Doctors like to believe what patients have to say. They're not going to go in there being expert witness testimony. All I'm telling you is that in people who have substance use disorder, it is not uncommon. And the thought was initially that because quetiapine was not addicting, that it's safe to give in people with substance use disorders, when in fact, we absolutely know it has street value.
Hey, what's up, Mark?
Absolutely know that.
How you doing?
Fact.
Right, but my point about this is you made a bunch of testimony about street value, but you knew at the time you made the testimony that Mr. Depp, in fact, had a prescription.
He also had a prescription for oxycodone and roxycodone. Does that count? Because that's...
Wow, that's an extremely evasive answer. Okay, so obviously what the lawyer's trying to pin down is that the doctor was trying to prejudice the clients by talking about street value as if Johnny Depp was slinging illegal drugs. Because when you talk about street value, you evoke memories of drug dealers. And you associate drug dealers with negativity. Liars, they're cheats, so characterizing that stuff in that way will allow the jury to prejudice the subject of that inquiry. And so the lawyer is attacking that characterization. Why'd you use that terminology? I think what he's trying to build up to is that Dr. Spiegel has... and I'm not sure, again, I'm not 100% sure about this, I'm just doing a prediction, that the lawyer is going to build up to the fact that Dr. Spiegel is negatively biased against Johnny Depp as the individual. That bias clouds his professional opinions and judgments. Let's see if he goes there.
Also, probably not a good thing. Just because you have a prescription doesn't
I
mean
think
that
Mr. Depp would agree with you it wasn't a good thing.
just because you have a prescription doesn't mean you can't abuse it.
No, I'm not suggesting you're abusing it. I'm just wondering why your testimony was in any way tied to street value when every single drug you referenced, Mr. Depp had legally.
Again, you can have prescription substance abuse, and we know that, correct?
Again, not answering the question. I mean, look, if this goes on much longer, the lawyer can ask the judge, objection, non-responsive. And the judge can order the witness to answer the question that was asked. But I think you get more, the lawyer is getting more out of the witness by having that answer stand before the jury. Because the jury is watching this too, thinking, why didn't he just answer the question?
No, I shouldn't be asking that. We can have prescription substance use disorders, and that's not uncommon if you look at the opiate epidemic that we're living
And he knows he screwed up, so now he's trying to play to the jury.
in right now. We can have that. That's not an uncommon thing. Unfortunate, but uncommon. Not uncommon.
So, Seroquel, I think you described as a sleeping agent when used off-label?
When I saw what?
Sleeping agent, Seroquel, when used off-label?
When used off-label, it's used. It can be used sleeping agent. Yes.
Right. So, Mr. Depp's use of Seroquel could account for some of the photos we saw in this trial, where he's asleep in a chair.
Again, what I would say to you is that if you have a substance use disorder, you are using it to be knocked out. Yes, I agree. But I'm not sure at the end of the day if she had vomitus over you either, because I've never seen Seroquel do that. So when he was passed out in the chair, he also had vomitus over him. I've never seen Seroquel do that ever.
Neurontin is another one of the drugs you testified about. That one's also prescribed, right?
Yes, it is.
And what's the prescription for that?
What's it used for? And what's its indication? Or what's it...
So that note that just got passed between the lawyers. When a witness answers something, and sometimes another lawyer just kind of has a twitch and is like, oh, that made me realize something. That note that they passed to the lawyers back and forth can say, ask this as a follow-up, ask this next, or try to get this info. Because, again, you can never predict all of the possible answers that you will get on the stand. You could try, and you'll be wrong. And so that's why a legal team... Oh, thanks for the sub, Mark. Appreciate it, man. Hey, how'd you end up over here? Who, did I just show up in your live feed or something?
Yeah, what's its indication?
I mean, its indication is for seizures. It may have one pain indication. Again, I'm not a neurologist, so I can't tell you exactly if it does. But it's chronically used off-label for pain. It's used off-label for anxiety.
Right. And what's its effect? That's another one that'll put you to sleep, right?
Well, yeah. I mean, sure, 100%.
Right. And you made reference to a picture. There's been testimony around that picture that Mr. Depp fell asleep with ice cream in his hand. That's not vomitous, right?
I was told it was vomitous.
Okay. You talked about the fact that Mr. Depp...
Okay, notice the lawyer didn't argue with that one. Because you can't argue with the way that someone has interpreted a picture. You're not going to be able to challenge that unless it's ridiculous. He testified that he was told it was characterized as vomit. And you'll see that the lawyer doesn't hang on that one because, again, that's not a lie. He believes it to be true. He can be shown evidence to the contrary, but that is of no benefit to you in this cross-examination. And so you'll see that the lawyer just lets it go, leaves it.
Indicates that from time to time he uses an earpiece.
I was, yeah, I mean, I read that, yes.
Okay. Did you read the testimony of Mr. Wyatt, who told you what was being pumped into that earpiece?
Yeah, I mean, if I remember right, I mean, I think it was lines, right?
No, it was music.
It was music, not his line?
Yeah.
Okay. It's
So
music.
if Mr. Depp,
So the lawyer did get away with one there, because that was not a question. He stated it was music, and I wonder if that was objectable. If that was, if you could object to that, the way he had said that, he could have gotten there. I mean, I'm guessing that the other team probably caught it and said, don't worry about it. It's not harmful, because I'm sure he could have gotten there somehow. You know, would you argue with me if you know, or do you recall being told it was music? No. If I said it was music, would you dispute that? Right? You could get there. So
was listening to music rather than being fed his lines, does that change your opinion as to his cognitive function?
If he was never fed his lines through the earpiece, which I know he was, but read he was, and that may have been that example. Mr. Wyatt may have said that it was.
okay, so you see that you see Johnny Depp and the other member of the legal team right there, when he says, "I know that he was being fed lines," and you saw that moment again. The witness said something, and they have a reaction to that. And you can see the Wayne up there, the lawyer, doing the cross examination with a pretty big smile on his face because he's like, "Okay, well, I just got something I needed. I definitely got something I needed."
Was music. I guess the question is, were you having the music during the actual talking of your lines? Is that what you're saying to me?
Well, you know, if you can do two things at once, that's a pretty high cognitive function, isn't it, sir?
You know, it's a very good point, actually. Divided attention is something humans have a lot of trouble in. So, for instance, we have trouble driving and putting on using our cell phones and direct. So, divided attention, humans actually are not very good at. I'll put that out there.
But Mr.
In general, not just Mr. Depp, in general.
But Mr. Depp is pretty good at acting. You acknowledged that early on.
Absolutely. Well, better than me, so I know that.
Because you don't act. In fact, you don't know about acting.
You're right. I have no idea about it.
Again, using his own words. This is something he testified to earlier. Using his own words.
And you don't know how prevalent the use of earpieces are in acting.
Again, I know nothing about acting.
Irrespective of the fact you know nothing about acting, you've testified that Mr. Depp's use of an earpiece is somehow a cognitive deficit?
So if I was giving a lecture and I was fed my lines, I would think there's a cognitive deficit. So and maybe I'm wrong. Like I said, maybe I could be wrong. Maybe Hollywood stars get lines fed to them through earpieces all the time, and I don't know. That could be said. It sounded to me to be unusual if you're doing a movie and you don't know the lines. But like you said, I'm just judging it on what I do with lectures, and that would never happen.
If you gave lectures, you wouldn't use an earpiece, but you're not going to tell anybody how to act.
I'm sorry, what was the question?
I said if you gave lectures, you wouldn't use an earpiece, but you're not telling anybody how to act.
Right, I would not use an earpiece during lectures.
Right.
But I don't know what the standard for standard as Hollywood is for that. I have no idea.
Your testimony about the use of an earpiece, as maybe you were wrong. You're comfortable with the fact that you may have made a mistake there?
No, because I think in the basis of what I've read about it, I'm comfortable that I don't believe that actors are routinely given their entire script through earpiece.
Interesting question. Okay, so we're drawing to the end here as the lawyer is starting to come in to the point of data or the point of evidence that he wants to pull out of this witness and put in front of the jury. Did you make a mistake in your assessment? Well, the witness disagrees. But again, we laid the foundation, we laid the premise. He doesn't know about acting, he doesn't know the prevalence of earpieces, and he based his assessments on those premises. So if the premises are faulty, then the assessment's faulty. But of course, then the witness disagrees with the lawyer on that conclusion.
I find that hard to believe.
Yeah,
But-
and
but-
there's not one whit of evidence that this ever happened here.
I guess what I said. I just said I find it hard to believe. I didn't say it. I said I find it hard to believe. That's all I said.
Oh, yeah, but what you found hard to believe, sir, was that every line of the script was pumped through an earpiece. Where did you ever get the idea that occurred?
That's what I have been. That's what I read in the court review, the court evidence. That's where I got it from.
Right. And you know whether Marlon Brando used an earpiece?
Whether isn't he dead?
Yeah.
So the answer is no. He does not use one now.
No, I used the past tense, sir.
Oh, I'm sorry. I
Beautiful face palm right there. Man, get a still image or a screenshot of that one. Beautiful
knew
face
nothing-
palm.
I will concede to you, I know nothing about acting. I will concede to you 100%. If that is the standard and people are done that's acting, then I apologize and that was wrong on my part. If that's the standard, I'm wrong. I don't know.
Bang. I am wrong. Right? Bang. This is how you catch. Now, I guess calling Dr. Spiegel a liar is probably doing a big disservice to him. But these techniques demonstrate how you catch people lying on the stand.
Okay. Let's go with that. No further questions.
All right. How long is your return?
A bit.
All right. So we're just going to leave that there for a second. Just to summarize some of the things that we went through with this video. And again, this is probably the best. I know the Amber Heard Johnny Depp trial is old news. This was not a showcase of this for current news. It was a showcase of cross-examination techniques. Now, Dr. Spiegel, like I just said, Dr. Spiegel he wasn't lying. I wouldn't say he was a liar. But what you saw were some excellent demonstrations of the techniques that lawyers use to catch liars on the stand. One of those techniques you saw used repeatedly was lay easily agreeable foundations. Do you characterize this as this? Yes. Do you say that this happened? Yes. Do you believe that this leads to this conclusion? No. Make them disagree with that, with a question that calls into question their testimony, but also is based on those premises that you've built up to. That inconsistency is what the jury will focus in on. You saw the other techniques, too, of cross-examination, which are not necessarily aimed at catching liars, but the way that you control witnesses on the stand. And you'll see this with witnesses, non-expert witnesses. You don't want them rambling or going off the subject matter that you're talking about. So questions will be phrased and asked in a yes-no fashion. And when the witness doesn't give you yes or no, and we saw this happen once in this exchange with Dr. Spiegel, did you say yes? So is that a no? Right? And you saw that come back. Again, the techniques here are because you're trying to craft. Again, two things. You're trying to craft this. Well, actually, you're the big bad wolf trying to blow down the straw hut that the witness has constructed. Because again, on their primary examination, they were allowed to speak freely, and you ask open-ended questions so that they can tell their story. So they've constructed the best possible, the best possible scenario for the opposing side, and you come into cross, and your job is to deconstruct that straw hut. And so you ask yes or no questions in a way that's designed to point out the weaknesses of their story, to highlight strengths of your own defense. And we can look at the other example of that would have been the cross-examination of Gage Grosskreutz from the Kyle Rittenhouse trial. That would have been another good one too, but that one was really, really long, and I didn't really want to take that long going through the video. But again, you'll see the techniques in use there. Yes or no questions. And I'm going to build up the premise. And then I'm going to execute the piece of evidence that I'm looking for that I can use in my closing statement. I will execute that, and I will either force you to admit to my conclusion or to deny my conclusion, both of which I can use in my cross. So the witness agreed with me that he was at the supermarket, and then the witness agreed with me that the supermarket was robbed. And the witness agreed that he had a face mask because it was cold. And he agreed that he carried a gun for self-defense and it was legal. But he claims he didn't rob the grocery store. Right? You can put that in front of the jury, and a jury will say, well, boy, that's, you're in a grocery store at the right time and you're there when it was robbed with a gun, with a ski mask, and you're saying you didn't rob it. Okay. But, and again, what you're trying to do is pull the piece of evidence that you're going to use for your closing argument. So the evidence here, I was wrong with my assessment. That was the coup d'etat. That's what the lawyer was looking for. I am wrong. I was wrong with my assessment. The other piece of info he was looking for is that the characterization of intimate partner violence as Johnny Depp being a perpetrator of intimate partner violence, when it's in fact Amber Heard that has the diagnosable risk factor. So he pulled out those pieces of evidence to present them to the jury later in the closing arguments. And you will hear that. Maybe we'll have a look at the art of the close, some other video. But for sure, you will hear the lawyer say, and the witness agreed with me that he was in the grocery store. And he agreed with me that he had a gun. And he agreed with me that he had a mask. And he agreed with me that the store was robbed at that time. But then he says he didn't rob it. I don't know if that's exactly how you'd run that close. I think that's probably the law student as opposed to the law practitioner, the difference between the two. I'm taught the theory, but I don't practice law. And now is probably a good time for the disclaimer. I am not a lawyer. This is not legal advice. Always contact a lawyer in your jurisdiction to obtain legal advice. But when I'm taught the theory of this stuff, and like I said at the start of the show, you're never taught how to cross-examine a witness, these techniques. You're taught the rules, what you can do, what you can't do. Because these types of things are, I don't know if those skills can be per se taught. Some of it goes to your instinct. Well, that answer didn't sound right. Some of it goes to being able to think quickly on your feet. That wasn't the answer I was expecting. And to be able to say, I can bring this back, because the answer I wasn't expecting, I can attack it. I'll give you a perfect example. So I was doing an exercise in cross-examination. But again, It was so it was in a mock trial. It was a mock trial. It was not a real trial, and I was not taught ahead of time. Okay, so this is the technique you would use to get to this type of conclusion. Something that they have to watch you cross witnesses, and then they'll say, okay, here's how you could have gotten to this place. And so I go up there to cross examine the accused. I'm serving the function of the Crown prosecutor. Again, in Canada, it's the Crown. In the US, it would be the DA, or the ADA, probably. DAs don't typically run cases, but an assistant district attorney, a member of the state. So I was performing the function of the Crown prosecutor and cross-examining the accused. I wanted to establish, and the accused had used, you know what, the details of the case are not that important. It would take a long time for me to fully explain all that stuff. But I was able to establish, based on the witness testimony, that the accused was pregnant, had alcohol to drink that night, and then got into a car to drive. I didn't need to prove that she was drunk. That was not what she was charged with. But the charges flowed from that chain of events. And those are facts I want to put in front of the jury. The defense called the accused to testify in her own defense, on her own behalf. She spun this great story. I had to attack the credibility of that story. I had to attack I had to attack the characterization that she was, well, again, I'm going too deep into the weeds. Anyways, one of the things I really wanted to go at was the compulsive actions that had occurred down the chain of events. Or not compulsive, impulsive actions that had taken place down the chain of events. And by establishing, first of all, I asked her if she agreed with me that drinking alcohol while pregnant was a bad thing, and she disagreed with that premise. So that was, again, an answer I wasn't expecting, because we accepted as common facts that drinking alcohol while pregnant is harmful to the fetus. But she disagreed with that. But I said, you know what? That answer actually works better. Because when I put that in front of the jury, they're going to make assessments about her credibility based on the fact that she thinks that she can drink alcohol while pregnant and not have any harmful effects on her unborn child. Now, I wasn't going for the character assassination on that one, but that's where it ended up. Because the character assassination is not, that's not really going to get me the victory in the trial. I was also, of course, able to get the witness to admit that they had left the scene of a crash without reporting it to the police. That was just a stand confession. But I also had to, dispute the characterization that the accused had made that she was afraid of for her life. And not that she was antagonizing for the fight. So I start there, setting up okay, so you drank alcohol while pregnant, then you get behind the wheel of a car. Again, I'm not trying to prove that she was drunk driving. Any amount of alcohol in your system negatively affects your ability to operate a motor vehicle. One drink impacts it not so much. It's an amount, the impact is so insignificant that we as a society have agreed that we don't consider that immoral. That's why it's not a crime for one drink. For most people, I guess. There are some people who maybe get drunk off one drink. I can't think of anyone I've ever met that would do so, but I'm sure one person exists out there. But yeah, that's why we tell you not to drink and drive, is because of the negative impacts on your safe operation of a motor vehicle. One drink does begin that process, but we've decided that that's not the line. But that was the premise that I had to start with. Had some liquor to drink. You were emotionally charged because of the confrontation that you had earlier that night, and you're doing all these things while pregnant. Hey, what's up? I'm just wrapping up here. I'm actually drawn down to a close for the video, but I'll leave the video up once I kill the live stream. You can watch the replay if you want. I'm just wrapping up here with a quick explanation of the mock trial. I always get distracted by the chat. If you're watching us on a replay, I'm just reacting to the chat. I always get distracted by them. They're so distracting to me. But, and again, and the way I get those points of information out, because I know the truth. I have the evidence in front of me. The other thing I wanted to nail this witness on is that they had a phone call with another witness and asked her to change her story. Of course, she did not mention that in the primary examination. She didn't say, oh yeah, I called up my friend, told her to change her story. I had to get that info out of her. But I did not ask it right away. Because if I just said, hey, did you call the witness and ask her to change her story? She would evade that answer, right? Because that's a damning answer if she agrees with it. So I had to build the premise. So I start. Do you recall having a conversation with so-and-so on this date? Yes, I did. And you talked about the aftermath of what happened on the date of the alleged offense. Yes, we did. And you, do you, how did I frame it? Oh, because it was a wiretap conversation. It wasn't something that was, again, it was evidence that was admitted in court, but it wasn't something she said. So in order to make this, I had to lay the foundation, right? And so in order to bring in the wiretap conversation, I had to ask her, do you recall saying, quote, you should go in and set the record straight, end quote. The witness reluctantly answers, yes, I told her that. Great, perfect. Admitted, right? She's admitted to saying those words. Now I can go and say, so would you agree to me? Would you agree with me that you're instructing the witness to change her testimony to the police? And she didn't say yes, because that is damning. So she tries to evade it and says, well, I mean, she said, she characterized it in a certain way, but that's not what happened. And I just wanted to tell her that, look, that's not the way it happened. What you saw is not the way it happened, and you were mistaken. And I just didn't want her to mischaracterize what had happened to the police. But that's the answer that I wanted her to give. That's the answer I wanted from the witness, because it looks bad when you put it in front of the jury. So when I go to do my closing argument, I can say, and you heard the accused testify that she called a witness and said, quote, go to the police and set the record straight, end quote. And when the accused was asked, was she trying to counsel someone to change their story, the police, she didn't have a response. You heard her response on the stand. She claimed she didn't want a mischaracterization to come into the record. Now ask yourself, why? Why would the accused not want the witness to characterize something a certain way? Well, because that characterization was that the witness saw a crime committed by the accused. You heard the witness testify that the accused committed the crime. And those are my techniques. And again, I cannot use that in cross unless I get, or I cannot use that in my closing statement unless I brought it out in trial. And there is no way that the accused was going to testify to the defense team those facts. The facts that actively harmed her own defense. I had to bring it out on cross-examination. And that, ladies and gentlemen, is the art of catching liars. Well, and you know what? I said the title of the video in the video. You know, I love when they do that in movies. Hope it's appreciated here. Well, that's gonna draw this to a close. This video I have for you today. Quickly over. So I can show my own channel. So of course, you're watching this on YouTube right now. I don't multi-stream. Maybe I'll get around to it someday. But right now, YouTube's the only place you can see this content. But this is my website. I don't have super chats enabled. I don't have enough subscribers yet. But if you want to support this content, I've basically set up my own GoFundMe. It's on my own website, lostinlaw.ca. That's LAWSTINLAW.ca. Where you can actually send me an anonymous... there is an option. I'll take you through this here. You can just send like a $5... a $5... Can't call it a super chat because I think YouTube actually has they might have a copyright on that. Or a trademark, I mean, on the term super chat. But anyways, you can send me a donation anonymously. Just check the box. And honestly, there's no verification or anything here. You can just put anything you want. The email address is only required to send you the receipt. It's not published on this website or anything like that. Your name is, and the comment is, if you do not choose the anonymous donation. I don't actually display them anywhere, but you would be able to, like, if you knew the donation receipt ID number, you'd be able to find the donation in the database of this website. But if you check the box, make it anonymous, then your name won't show up. Still leave the comment though. And this is, and you know, keep it clean, as clean as you can. And if I get one, I'll read it on the show. Let's see. We're coming up on quarter after here right now. Leave yourself there you go. He's room if you want. Essentially, yeah, not this money is free. It's not an expectation. I'm not creating any sort of contract with anyone. And then you can, you know, it'll be really funny is if my credit card pulled up in the autocomplete of this field here. Oh, that would have been hilarious. But anyways, I'll just point that out to you real quick. We'll support the channel. Getting court transcripts, stuff like that, upgrading some of the equipment, that takes money. So if you can help out, I'd appreciate it. If not, I hope you enjoy the content. Until next time, everyone. Peace. Stay frosty.